As we were deciding who would play Lily, many names were suggested, and at one point, Blake Lively's name came up. I found it fascinating to see the reactions of the women in the room as we discussed potential candidates, with many lighting up at the mention of Blake Lively. For me, it was crucial to cast someone as Lily who would be approachable, likable, and relatable to women. Welcome back to my channel. Something incredible just happened, and I'm convinced Ryan Reynolds and Blake Lively are following my Instagram. Hi, Ryan and Blake. On Saturday, I posted about Vans Incorporated, the company they used to access Jen Abel's phone through a subpoena in the Vans Incorporated versus does 1 through 10 lawsuit in New York. I revealed that the company was past due in New York, meaning at the time the lawsuit was filed, it's questionable whether they could have had a valid contract with anyone. Seeking court relief in September would have been dubious, since they were not in good standing. Additionally, they misled the court by claiming the records were publicly available and that Vanson's officers and directors could be viewed online through the Secretary of State. I obtained their 2019 articles of incorporation, which showed they never filed a biennial statement as required by New York law, nor updated the directors, officers, or shareholders. The original filing listed only a registered agent, with no mention of Ryan or Blake's names. Then, today, Ryan suddenly updated the biennial statement for the first time in the company's history, filed with the New York Secretary of State. I obtained a copy, dated today, listing Ryan Reynolds as the sole chief executive officer. Blake's name is absent. The registered agent is the management company handling their businesses. The filing states there are 2 directors on the board, with 0 women. This filing came after I exposed their delinquency and after Ellen Goff informed the judge that Vanson was Blake Lively. In my view, this is revisionist history to hide Blake's involvement with Vanson and shift scrutiny to Ryan, who is now a non-party. If Ryan is Vanson, Blake may avoid liability for Vanson's actions, but it's a bad look. Here's what their attorney, Ellen Goff, stated in her Saturday answer and counterclaim. Abel contends that Stephanie Jones and Jones Works collaborated with non-party Lively and her counsel to create a sham lawsuit solely to obtain documents Jones pirated from Abel's phone and iCloud without waiting for discovery in anticipated litigation against Justin Baldoni and Wayfarer Studios. Lively admits the Vanson action was a sham, designed to obtain Abel's text messages as part of an investigation before filing her claims against the Wayfarer parties. Abel has subpoenaed Vanson for information about its ownership, whether controlled by Lively or Ryan Reynolds. We now know it's controlled by Ryan Reynolds. Abel also seeks a copy of the Vanson subpoena served on Jones and the documents Jones allegedly produced in response. Vanson objected, arguing the information is irrelevant and, as a non-party, they shouldn't be required to produce documents available from parties in the litigation. They'll claim Vanson isn't Blake and Ryan, as a third party, shouldn't have to provide anything. This is revisionist history and gamesmanship. Even if Ryan controls Vanson, it's a terrible look. If Ryan filed the lawsuit, not Blake, and claimed defamation or a confidentiality breach, it raises questions since he had no contracts with Justin Baldoni or Jen Abel. His only connection might be payment from Sony for film marketing, but why would he sue over Abel's phone? This suggests manipulation of the court. Abel's motion to compel seeks Vanson's communications, including those between Jones, Lively, and Vanson, or their counsel, related to the sham Vanson action and subpoena. Vanson and Lively argue these communications are irrelevant and not discoverable from a non-party, but Abel asserts Lively is Vanson, making production reasonable. Lively admitted the Vanson action was a sham and the subpoena was a tool to conceal her identity. By updating Vanson's records today to list Ryan as CEO, they're trying to distance Blake. However, spousal privilege doesn't apply if Ryan acted as Vanson's CEO, not as Blake's husband. Since they share attorneys, they appear as one entity, as Wayfarer and Abel have argued. These communications are central to Abel's claims that Jones and Lively conspired to obtain stolen information via the sham Vanson lawsuit, providing a veneer of legitimacy for Jones transferring Abel's data to Lively. They may also show if Jones provided Abel's stolen data to Lively before the subpoena, using it as a cover for wrongful disclosure. There's no rule requiring party sources to be exhausted before third parties produce relevant discovery, and Vanzen hasn't justified withholding these communications. Abel requests the court compel Vanzen to produce documents responsive to request number 9. Lively's admission that she received Vanzen's subpoena contents and that the action was a sham confirms she is Vanzen. The lawsuit was closed after obtaining the evidence, which wasn't used for its stated purpose, suggesting it was a ruse to launder evidence through a lawful subpoena. Ryan's filing today, the first since 2019, claims he's the CEO, despite previously distancing himself. Their attorneys argued in 2025 that husbands don't speak for their wives, yet Ryan's company is now involved in Blake's dispute, suggesting he's acting as her agent. This could strengthen claims of malice and coordination. A lawyer I consulted anonymously suggested deposition questions for Ryan. Why did your shadow company subpoena Stephanie Jones in a breach of contract suit? Why was the subpoena's scope so broad it didn't meet standards in the later SDNY case? Why were you satisfied with one phone's contents, not noticing missing metadata? Why did the evidence end up with your wife and the New York Times? This framing makes Ryan appear to be driving the feud, using Blake as a shield, indicating malice and agency. The lawyer noted Ryan and Blake are a team, playing whack-a-mole, with discovery to evade accountability. Spousal privilege doesn't apply to Ryan as Vanzen's CEO. Updating Vanzen's records now can't retroactively change its non-compliant status when the lawsuit was filed, missing biennial statements for 3 years. This doesn't alter Vanzen's lack of standing or the absence of named officers at the time. Judge Lyman previously dismissed claims against Ryan, citing no evidence of agency, but this new evidence suggests otherwise, potentially grounds for Wayfarer to appeal the dismissal. Ryan may believe he's shielded by the dismissal with prejudice, but an appeal could overturn it. The judge's prior rulings, including quashing similar subpoenas as privacy invasions, contrast with allowing Vanzen's access to Abel's data. If the judge overlooks this, it raises questions of bias. This strengthens Wayfarer's case for malice and coordination, showing Ryan and Blake as a single entity. Ryan's actions suggest he thinks he's outsmarted the system, but I hope justice prevails. Let me know your thoughts in the comments. Give this video a thumbs up, subscribe, and click the bell to never miss a video. Thanks for watching. Bye.